Good afternoon, or depending on where you may be joining us from, good morning, and welcome to today's program, USPTO Hour Updates on Interview Practice and Patents. I am Sean Hunter, the Director of the Office of Patents Stakeholder Experience here at the United States Patent and Trademark Office. The USPTO recently unveiled 7 Patents Business Unit priorities, which are represented by the acronym INVENTS. Each priority represents the agency's commitment to strengthen the U.S. patent system, enable innovators to secure patent protection for their inventions, and provide durable patent rights that make the United States intellectual property system the best in the world. With that, it is my pleasure to introduce Daniel Ryman, Assistant Commissioner for Patents, and Yvonne Biney Eiler, Director, Technology Center 1700. Dan Ryman serves as an Assistant Commissioner for Patents in the Patents Business Unit at the United States Patent and Trademark Office. In this role, Dan works with and provides executive leadership to the Office of Patent Training, the Office of Patents Stakeholder Experience, the Office of Process Improvement, the Office of the Chief Patent Statistician, and Technology Centers 1600 and 3600. Previously, Dan has served as an Assistant Commissioner providing executive leadership to the divisions in the Office of International Patent Cooperation, as well as Technology Center 2900, which is our Technology Center. Dan has also held the positions of Associate Commissioner for Patent Quality, Director of Office of Patent Quality Assurance, Senior Advisor to the Undersecretary and Director of the USPTO, Senior Advisor to the Deputy Commissioner for Patent Quality, and Supervisor in both the USPTO's Central Reexamination Unit and Technology Center 2400. Dan started his career here at the USPTO as a patent examiner, focused on applications related to multiplex communication. Dan has a bachelor's degree in electrical engineering from the Colorado School of Mines and a law degree from the George Washington University Law School. Yvonne Biney Eiler serves as a group director in Technology Center 1700, overseeing the areas of chemical and materials engineering. Ms. Eiler joined the USPTO as an examiner in 1995. She became a manager in November of 2000, serving as both a SPE and a quality assurance specialist within Technology Center 1600. Bonnie holds BS degrees in both biology and chemistry and a master's degree and PhD in viral immunology from Rensselaer Polytechnic Institute. With that, it is my pleasure to turn things over to Dan and Bonnie.
Thank you, Sean. May I have the first slide, please? So we will begin today by just an overview of interview policy from our MPEP. Interview policy really has not changed at all. Interviews are still highly encouraged. Interviews should be granted when they serve to develop or clarify outstanding issues in an application. Interviews are encouraged because they aid the examiner in understanding the invention and applicant's arguments. They also aid applicant in understanding the examiner's position in the application of the prior art and the interpretation of the claims. Interviews help to facilitate a collaborative identification of patentable subject matter, and in many other ways simply promote compact prosecution. And again, I repeat, they remain highly encouraged here at the office. This graph shows us the frequency of interviews that occurred in disposals over the last 2 fiscal years, fiscal year 24 and fiscal year 25. You can see that there are a lot of interviews that have occurred, and nearly 36% of our disposals have had at least one interview conducted in them. Recently, you may have heard of some time changes with regard to interview, so we'd like to give an historical perspective of time and then cover what has changed recently. So historically, with SPE approval, examiners received 1 hour of non-production time or attribute time for applicant-initiated in-depth interviews, i.e. those interviews that move prosecution forward. That hour was a half an hour for preparation for the interview, and then a half an hour for holding the interview. In fiscal year 2009, examiners received 1 hour of non-production time for examiner-initiated interviews as well. We saw a vast increase in the number of interviews at that point in time. In fiscal year 2021, examiners automatically received 1 hour of attribute or non-production time for every interview summary that was entered on the record. We did that to streamline the process, so we essentially automated the process and linked it to the entry of the interview summary on the record. In fiscal year 25, as part of our efforts to reduce pendency, we evaluated the use of attribute time or non-production time by examiners, and we detected that there were instances of inefficiencies associated with the automatic grant of interview time with the entry of that interview summary. There were instances, while not widespread, they still were occurring, of attribute time of an hour being granted for interview summaries documenting phone calls or documenting approval to fix simple grammatical mistakes. That was an unintended consequence of the automation of that grant of time. So, for fiscal year 26, in order to correct that unintended consequence, we updated the interview time. Examiners will still automatically receive 1 hour of non-production attribute time for an interview in a new case or in a newly filed RCE. After that, for second or subsequent interviews, supervisors will need to approve the additional interview time. It will no longer be automated. However, interviews continue to be highly encouraged, and there are no other changes in policy. It was just a correction of the automation. The SPEAK considerations for granting that additional interview time include determining whether a previous interview was substantive in nature, whether the current interview furthers prosecution, and the level of involvement needed by the examiner to prepare for the currently requested interview. These are just examples and a high overview of what a SPE will consider when granting the time to the examiner for holding the interview. This change was announced to examiners in October of 2025. Examiners then received training on this change in October 2nd and October 7th as part of their PAP training. Additionally, just yesterday, we had another refresher session with examiners to clarify that interviews are still highly encouraged. That time is still available for second and subsequent interviews, and that time just needs to be approved by a supervisor. I'm going to turn it over to Dan now to cover tips and techniques for a productive interview.
Thank you very much, Bonnie. So after underscoring the continued importance of interviews for examiners and applicants here at the USPTO, we thought it would be good to go through a couple of tips and techniques to make sure that your interviews are productive. So to start, wanted to discuss when is the best time to request an interview to ensure that it is productive. There are two main time frames that we wanted to discuss here. The first is after first action, and the second is after final. So after first action is a ripe opportunity for applicants and examiners to discuss the merits of the case. We can walk through the technology that is involved. You can go through the rejection and the explanation of the prior art. It is also a ripe time to talk about potential amendments to the claims in order to overcome the rejections of record. Another instance for productive interviews is after final. These will typically be granted in instances where the interview will simplify issues, will clarify positions for appeal, or will place the application in condition for allowance. I did want to underscore that these will typically not be granted to restate arguments or to discuss new limitations which would require new search or more than nominal reconsideration. Two other instances in which we have seen requests for interview happen, which are less likely to be granted, are before first action and then after the mailing of a notice for allowance. With respect to first action, these are fairly rare, as I just said, given the limited issues that may benefit from discussion. That being said, the examiners do have the authority to grant interviews in these instances when they will move prosecution forward. And those include instances in continuations, and prior to a continuation, such interview requests are typically granted. An instance in which interviews are rarely given is after the notice of allowance. In this instance, the case is no longer within the jurisdiction of the examiner. And to get a grant for an interview in that instance, it will require the specific approval of a TC director, and the applicant will have to make a showing in writing of extraordinary circumstance. Turning now to preferred ways to request interviews, I wanted to use this opportunity to highlight the importance of the automated interview request form, or AIR form. This is a convenient web-based tool that applicants can use to request interviews. By using the form, applicants can put in a request for the interview, the format for the interview, as well as suggested times for the interviews. The system will then email both the applicant and the examiner with the request, and the examiner will get back to the applicant to schedule the interview, if granted, within 2 business days. You can also use telephone or call the examiner through the telephone in order to schedule an interview. This is also a common way to schedule interviews. Less preferred methods include doing it in writing or through email. If you do choose to avail yourself of writing and you don't hear back from the examiner in a short amount of time, please pick up the phone and give the examiner a call. Looking now to preferred ways to hold the interview. Did want to highlight the importance of video conferencing. This does allow face-to-face collaboration no matter the location of the parties. It does facilitate sharing and real-time editing of documents, which is a critical piece, or the reason why we would highly encourage people to use video conferencing. One thing I do want to underscore here is the video conference must be hosted by the examiner using USPTO systems, so it will be up to the examiner to set up the interview using our team software here at the USPTO. As noted before, telephonic communications are still highly popular with applicants in order to communicate with the examiners. I do want to underscore, though, that using the telephone does have limited ability to view documents collaboratively, which is, again, why we highlight the importance of video conferencing. And as a quick reminder, in-person interviews, while still available, in theory, are realistically not available when the examiner is working remotely, which is true for most of the examiners here at the USPTO. I want to underscore here the importance of the interview agenda. As a former examiner, I want to emphasize how important it was, at least for me, when I was looking at interviews. The agendas do allow examiners to prepare for an interview. They can evaluate the applicant's arguments in advance of the interview and allow them to provide substantive feedback during the interview. Examiners also use interview agendas when determining whether or not to grant the interview. All right, here are some tips then to make an interview productive. Going back where we were at the last slide, underscoring the importance of an agenda in advance of an interview. With the agenda, you should be as specific as possible about the issues to be discussed in order to allow the examiner to adequately prepare. This would include pointing to specific claim limitations that you would like to discuss, and also providing specific paragraph and line numbers from references in the specification. It's also very beneficial often to allow time to discuss the technology and the claim interpretations at the start of an interview to make sure all parties are on the same page as to how each other are viewing both the references and the claim interpretations. Also want to underscore the importance of organizing and framing issues to allow for a productive discussion. As Bonnie mentioned, the typical length of an interview should be about a half hour. And therefore, you should look at highlighting the important points that you want to make earlier in the agenda to make sure that you're able to cover them within the time frames. Also want to underscore the importance of framing the issues in a way to allow for a collaborative conversation. I will just say, from my own perspective, I have been privy to interviews as an examiner where the attorney would just come in and rehash arguments that were already of the record, which was not necessarily productive use of our time. So really wanting to underscore the importance of bringing issues that warrant a discussion in order to allow for that collaboration to happen during the interview. Final point is that it's the best practice to close by summarizing the discussion points to make sure everybody's on the same page as to what happened during the conversation and also about next steps. All right, so what to do if the interview is denied? The first is to make sure that you communicate with the examiner to understand the reason why the interview is being denied. If after a conversation you still feel an interview is warranted, you are always free to reach out to the examiner's supervisor to discuss the issue with the supervisor. And as a last resort, you can also always reach out to the Patents Ombuds's office for consideration of your interview request. Finally, wanted to go through some of the interview resources that we have available on our interview website. First of all, you can go to that website to access the AIR form. Again, a very important way for you to think about requesting interviews going forward. The website also includes a lot of tips and techniques on how to conduct interviews and training, especially on how to use the Teams software if you're unfamiliar with it. Another key feature of the interview website is the listing of interview practice specialists. These are individuals in every tech center who can answer questions you may have on interview practice. They can provide one-on-one training on the team software, and they can just answer any other questions you may have about how to conduct a productive interview. All right, so this is the conclusion of our presentation. A couple of key takeaways is, first of all, I want to underscore that interviews are highly encouraged as a way to advance prosecution. As Bonnie noted, second interviews in a round of prosecution should be granted if the interview serves to develop or clarify outstanding issues. And if you do get an interview request denied, you can always reach out to the examiner supervisor or the patent ombuds's office in order to seek having that granted. Again, I want to underscore the importance of using the AIR form to request an interview, and that you could leverage interview practice specialists for questions or teams training. And if you have any other questions, you can always look to the interview website for more information. With that, it's back to you, Sean.
Thank you, Dan, and thank you, Bonnie. Let me first say thank you both for being a part of today's program and taking time out of your busy schedules. With that, we will get started with our Q&A segment of today's program. As a reminder, questions were taken in advance. You can still submit questions during the program today at USPTO Hour at uspto.gov. And I see there's a constant flow of questions coming in as the presenters have been speaking. So we'll go ahead and get started with the questions that we received in advance, and we'll get to the ones that we can if time allots. First question. In instances in which a first interview and subsequent reply to an outstanding office action or sua sponte withdrawal of the office action by the office has resulted in either 1, the withdrawal of rejections without amendment, 2, the vacating of the office action for any reason, or 3, any other reason by the result of which a next office action is mailed that did not result because of amended claims, submission of evidence, or other material requiring further search and or consideration, can someone please explain why the applicant should be denied a request for subsequent interview even if the 1 hour allotted time has already been exhausted by the first interview?
So there was a lot in that question, so I will try to summarize it, and then Sean, please chime in if I miss anything.
Sure.
So I'm understanding the question to be that there was a first request for interview, and the interview was conducted, and then there was continued prosecution, and they're seeking a second interview and asking whether or not that interview will be granted. Going forward, as long as the interview, the second request for the interview is something that will move prosecution forward, that should be granted. Instances in which we have seen which will not move prosecution forward is if it's just a mere recitation of the arguments already of record, things along those natures. But generally speaking, if it is a request for an interview and it's going to move the prosecution forward, it should be granted.
Okay, understood. Thank you for that. All right. Is an interview available for each prosecution round? For example, one for the first round and one after an RCE is filed.
I can address that one. And the answer is yes, absolutely. The automatic grant of an hour of interview time is available with each new round of prosecution. So with a new case, with a continuation, with an RCE, the automatic interview hour is granted. Even once the automatic interview hour has been granted, if there is a need for a second and subsequent interview, that time is also available with SPE approval.
All right, thank you for that, Bonnie. Let's see. There are tons of questions coming in, so you guys can keep them coming. I am trying to get back to the beginning of that list of questions. What is considered non-production time?
I can cover that. So examiners track their time and are held accountable for a work product to be created in the time that they work. Time in which they are responsible for producing an office action, a work product, is called examination time. Examination-related time in which an action is not being produced is what we call non-production time or attribute time. So an interview, while it moves prosecution forward in an application, doesn't result in an office action. And so that is considered non-production or attribute time. Those two are really synonyms. We use them interchangeably.
All right, thank you for that, Bonnie. Let's see. I have had, I'm sorry, my screen is jumping a little bit here. I have had 2 interviews decline in the past 2 weeks when requested prior to filing a response to a final office action. Examiners appear to believe that no interviews will be granted on final office actions. Can you speak to that? It seems like the question is directed to, or the statement is directed to, there seems to be a disconnect between the presentation and this particular scenario.
Sure. So that instance should not be happening. As Bonnie mentioned, we did actually go and have some training yesterday with the examination court to reiterate. I believe the team is also planning on going out and doing some road shows with the technology centers to reinforce the current position of the office, that we are continuing to encourage applicants to be granted the opportunity to have interviews with examiners. So if you did get denied, feel free again to reach out to the supervisor, to have a conversation with the supervisor. And if that does not work, reach out to the patent ombuds. But as long as the second request for the interview is, again, moving the conversation forward, moving prosecution forward, the supervisor should be granting the time for the examiner to be having that interview.
All right. Thank you for that, Dan. Let's see. Can you give clarification of what is meant by, quote unquote, in a new application or RCE, where one interview attribute hour is automatically received by examiners? When is an application no longer considered, quote unquote, new for this purpose?
With the automation of the hour linked to the interview form, a case that is newly filed and hasn't had an interview in it yet would have an automatic grant of interview for the first interview summary that gets entered in the record. Once an RCE is filed, that case is considered new again. It's rolled over, it's starting again. And so that automatic grant will reset. So then another interview summary entered in that case will result in an automatic hour. After the first interview with the automatic hour is granted, then the examiner has to ask the SPEs for approval.
Okay, thank you for that, Bonnie. Let's see, what else do we have here? Can an interview be utilized to discuss after final claim amendments?
Yes, so interviews can be used to discuss after final claim amendments. That being said, the way that the policy is set up is that they should only be used, though, to discuss if you're looking for a decision by the examiner. It should only be for something that is not going to require a substantive search, right? So if you're looking at how, whether or not they overcome the art of record, that would be right for discussion. But if you're looking to say whether it overcomes all of the art out there, i.e. making the claims allowable, that would probably be denied because it would be outside of the scope of the interview.
Does the applicant have to provide any interview materials for an interview, even before the examiner or SPE grants the interview request? Historically, such materials are not required until after the interview is scheduled.
So applicants are not required to provide an agenda in advance. That being said, they do need to provide enough information about what they want to discuss with the examiner for the examiner to be able to determine whether or not to grant the request for the interview. That being said, it is a best practice to provide the agenda as far in advance as possible to give the examiner the ability to really, first of all, if it's before the request or as part of the request, to have a good understanding as to what the applicant is intending to get across through the interview. In addition, it gives them adequate time to prepare for the interview if the interview is granted.
Is video conferencing a request option in the AIR form? If not, should video conferencing be specifically requested, or will the examiner suggest that it is in fact available?
I can cover that one. Yes, the AIR form does give an option for the type of interview to be held, and video conferencing is one of the selections that you can ask for. If you're not using the AIR form, you can also ask the examiner when you call them to make it a video conference.
I have a question on whether or not filing an Internet Communications Authorization Form is mandatory to communicate with an examiner via email. So is that Internet Communications Authorization Form mandatory if they would like to correspond via email with an examiner?
I'll cover that. Yes, it is mandatory to file that form and to grant authorization before you can communicate via email with the examiner. Also, communications about an application that are done via email after the authorization has been granted and made of record, those email communications will also need to be printed out and uploaded into the file and made of record as well.
All right. Thank you for that, Bonnie. Can we record the interview? I think you guys mentioned Teams or other video conferencing, teleconferencing options. Can those interviews be recorded?
Interviews should not be recorded. Although the office currently does not have an official policy on the issue, we generally tell examiners that they should not be recording interviews, and also if they recognize that an attorney is recording an interview, to ask them to stop recording. So again, right now, examiners and attorneys should not be recording interviews.
All right, understood. Speaking of error request, does the error request also notify the supervising examiner if the examiner is a junior examiner that a request for an interview has been made?
It is, I will look to Bonnie to correct me on this. It is my understanding that the supervisor is not included on the email communication. That being said, the junior will be in active communication with their supervisor. I think what this is getting to a little bit is we do have this concept of negotiation authority here at the office, and examiners below a certain level do require to have somebody with negotiation authority in the interview with them. And examiners know whether or not they have negotiation authority, and if they don't have negotiation authority, they will be working with somebody who does have negotiation authority to stand up to the interview.
Now, we'll add that while I agree, I don't think the supervisor receives an email, there is a flag raised in the case, and the supervisors can see the interview flags in the cases on the examiner's docket, so they can check to make sure that interviews requests are being granted.
Is an agenda required for an interview request to be granted?
An interview agenda is not required for the request to be granted. However, it is a best practice for the agenda to be sent as part of the request. As I noted as an examiner, and I believe I speak for a lot of examiners, that the interview agenda is very, very helpful when figuring out whether or not to grant a request for an interview. In addition, the sooner that an examiner gets the agenda, the sooner they can start preparing for that interview and make sure that they are adequately prepped up to substantively discuss the issues with the attorney if the interview is granted.
All right. It seems like many examiners and practitioners may prefer telephone because of no camera. Is there a preferred way to request camera off Teams conference calls for screen share purposes?
I am not aware of a way to request that. I'll look to Bonnie to see if you're aware of any nuances there.
At least in the AIR form, there is no way to request that the camera be off. But I'm thinking certainly once you've started the interview,
Sure.
you can ask the examiner. You can indicate you really love to share the screen, but don't necessarily want the camera. I would highly recommend using the camera, however. It may feel weird at first to be on a camera and to see yourself on the screen and to be talking to the webcam, but it does enable a face-to-face interaction. You can see each other and you can see each other's expressions. It really does help in the communication to be able to have that face-to-face interaction, even if it's on a screen.
Okay, thank you both for that. Let's see. I think you may have touched on this already, but I'll ask the question that came in anyway. Can an examiner and applicant use email to communicate?
Examiners and applicants can use email to communicate. However, there needs to be an authorization on the record that email communication is an accepted way to communicate for this. And as I believe Bonnie noted before, any email communications that do occur would then be made part of the record.
Okay, thank you for that. how long, of a lead time is there between asking or requesting the interview versus actually having the interview? If I ask, for example, if I asked for an interview today, would the interview be 12 months later? I'm sure that's an extreme example, but I guess what they're asking is the expectation. What is a reasonable expectation of time between the request and the actual interview taking place?
There's certainly going to be some variability depending on your schedule and on the examiner's schedule. There's going to be at least a 2-day window between the request and the time that the examiner gets back to you. Then I'm thinking back to myself when I was an examiner. I did grant a lot of interviews. I would try to get the interview schedule within a week or two of when the request was. That was stacked up with other interviews that were happening. So for me, I'm thinking within the bye week that the examiner's working in, within the next week or two, maybe 3 at the most, would be a reasonable time for that interview to get scheduled.
Sure.
Like there, again, I can only speak for myself as an examiner, but it was usually I would want to request a week or 2 out in order to give me time to schedule something, to work it around whatever I may have on my docket, and then also to give me time to prepare. I'll also flag you may run into instances where an examiner is out of the office. So it is beneficial to at least give you 1 to 2 weeks of lead time to be able to understand what the examiner schedule is and to get something set up. I would not wait until the last minute. That being said, I also would not wait 12 months.
What should practitioners do if an examiner seemingly is not prepared for an interview, even though they maybe received the agenda a day in advance? So this sort of dovetails nicely into the previous question. Again, what should they do if it seems like the examiner is not fully prepared for the interview? But it also sounds like in this question, the agenda was only maybe provided a day before.
Sure, I'll start and then I'll let Bonnie jump in. So from my perspective as a former examiner, if it was only given to me in a day in advance, I may not have had a chance to really go through it. And so in that instance, if I'm not prepared, right, I would probably be asking to have the interview rescheduled for a later time. At the same time, if the attorney is finding that the examiner is not adequately prepared, you may want to ask if we can reschedule in order to give the examiner appropriate levels of time in order to get up to speed on the particular issues. But I think the assumption there is a day may be adequate, and I'm not sure that is an adequate amount of time given whatever else is on the examiner's agenda for that day to accomplish in order to prepare adequately for an interview.
Yeah, I would agree with that. The examiners have a lot of cases that they're working on, just like you, with a docket. And it does take them time to get into the case, get reacquainted with what's going on in that case, and be prepared for the interview. Having an interview when you're not prepared is not going to be as productive as an interview in which both parties are prepared. So my instinct would be to reschedule that as well so that it can be a productive interaction.
All right. Thank you both for that. If I make a phone call after receiving an office action that is only maybe 10 minutes to ask a couple of quick questions, is that still considered an interview?
If it gets to the merits of the case, then it would be considered an interview and it should be recorded. That is a separate question, though, of whether or not an examiner would be authorized an hour's worth of time for that communication. So one of the takeaways from this is that the ability of an examiner to grant an interview is not the same as whether or not they get an hour. And yes, any time that you do substantively reach into the merits of a case or discuss the merits of a case, it is considered to be an interview, and it should be documented in the record to make sure that once the application publishes that as a patent, that the record is complete as to the conversations that were happening.
Okay, thank you for that. If a final office action has new grounds of rejection, shouldn't an interview after final be granted in that case to discuss the new grounds of rejection?
After final is usually a very productive time to have interviews. as I noted during the presentation, that there are a little bit of constraints on there. So interviews will be granted if they are clarifying issues, which I think is what was being asked in this question. If you are moving prosecution forward, if you're putting the case in better condition for appeal or for allowance. That being said, open-ended conversations about claim amendments that may not be granted given the status of the application as being after final.
All right, let's see. You mentioned that the applicant may contact the SPE if the interview is denied. If the examiner does grant the interview, but the result of the interview does not resolve the applicant's concerns or questions, is the applicant able to request a second interview with the involvement of the SPE?
I'll maybe defer to Bonnie. I'll start the answer here and I'll see if she has anything to weigh in. If you do have a conversation with an examiner and you think further conversations are warranted, you're always free to request additional conversations with the examiner and even to have the supervisor present. That would be a conversation with the examiner and also with the supervisor to make sure everybody's on the same page as to the expectations of what the further conversation is, why they may be beneficial, why they are advancing prosecution, and then it would be up to the supervisor and the examiner to grant or to deny that. I will say from my experience as an examiner, I would grant in those instances because I would feel that the conversation was being moved forward, and I wouldn't necessarily limit to 1 hour for a single conversation. Again, as long as the conversations are productive, I personally would have been granting that. So that would be a conversation with the examiner and the supervisor.
The other thing I would add is there's a time element that will be introduced by requesting another interview with the SPE present. There are a lot of cases that the examiner is working on. There are even more cases that the SPE is reviewing. So in order to give the SPE time to come up to speed on the issues in the case, you're introducing at least a week for the SPE to be able to get acquainted with what's going on in the case, talk to the examiner before they'd be able to be prepared to facilitate a productive interview. So to keep that in mind, that it wouldn't likely be an instantaneous turnaround.
Okay. Thank you both for that. Let's see. During the interview, is it possible and appropriate to show the examiner a very brief video explaining the invention in 3D and in motion in a real live situation, perhaps showing a prototype in action?
My first response to that is cool, sure.
Okay.
I would reiterate that I think that would be an appropriate thing to happen during an interview. I'll just say personally, as an examiner, this was taking us back a while. We didn't have the collaborative tools that we do today, but I do recall applicants coming in and demonstrating their product live during the interview. I think this would essentially be replicating that. And I think this underscores, again, the importance of why you would want to use a Teams interview setup, because this would allow for that sort of thing to occur.
Sure. Okay. For complex chemical and materials cases handled by TC 1700, are there specific guidelines or examiner preferences regarding the format and timing of pre-interview submission materials, especially when trying to clarify sufficiency of disclosure or new experimental data?
No, there's no specific format or requirements for what you would submit. I will acknowledge that some of the subject matter that comes into my TC can get pretty complex. So the more that can be provided to enable the examiner and anybody else who's attending the interview to prepare would be helpful. But there's no specific format for how and you would provide that information.
What will be considered, quote unquote, sufficient to move prosecution forward to justify a second interview to be conducted prior to filing an RCE when the only remaining issue is an outstanding 101 rejection?
So I don't know if there's a one-size-fits-all answer to this, just given that there's a lot of nuances that happen with each individual case. In my opinion, what you're really looking at, or what I'd be weighing as either a supervisor or as an examiner, is is there a difference of opinion that we are working through clarifying, or is there a conversation about potential claim amendments that could be had in order to overcome the rejection of record? I think both of those would be ways to move the prosecution forward. I don't know, Bonnie, if you have anything to add on that.
No, I think that pretty much covers it. I mean, certainly if you're discussing the merits of the rejection, I would think that involves a good bit of preparation.
Okay. You mentioned that the interview agenda will be used to determine if the interview is granted. What is the best practice for submitting the agenda? Previously, it would be sent to the examiner after an interview was granted.
Sure. So I'll first underscore that I think, there's a variety of different ways that you can be reaching out to the examiner. And that you could also, when I say an interview agenda, it may not necessarily be a formal document at that point. I think the key here is to be able to articulate to the examiner the specific details that you would like to discuss during the interview, be very clear about what the issues are and why they are relevant to moving prosecution forward. So when I was alluded to before that it's important to have an interview agenda and that the examiners may consider it as part of their determination, that doesn't necessarily mean that it would be a formal document submitted at the time. But to me, as part of the request, the applicant should be able to articulate, again, the specific issue that they want to discuss, as well as the particulars of those issues that need clarification.
Okay. Thank you for that, Dan. Since the point of interviews is to advance prosecution, does it matter whether proposed claim amendments are discussed after a non-final versus final office action?
To me, the difference is going to be, again, there's a slight nuance between after a first action and after a final, in the sense of after a final, prosecution is closed. And so the conversation should really focus more on narrowing the issues for appeal, getting to allowance. Any conversations of claim amendments really should not be getting into things that would require a reconsideration for a larger search. Those restrictions aren't necessarily present if a conversation is being had after a first office action. At that point, I think the realm of conversation is broader. So to me, that would be the difference between the two timings of the interviews.
Okay. That's helpful. Thank you for that, Dan. Is it possible to allow the submission of an agenda as an attachment when using the AIR form?
I believe the answer to that is yes. I believe that there's, like a normal internet form, there's an attachment function to add the agenda.
Okay. Are agendas automatically part of the file history, or is inclusion in the file history at the option of the applicant or the examiner?
The agendas should be made part of the record. And again, the substance of the conversation will also be made of record through the interview summary form, but you should be attaching the agendas as part of that summation.
Okay. Do examiner-initiated interviews count towards the applicant's one automatically granted interview request?
I can answer that, yes. Examiner-initiated and applicant-initiated interviews are treated equivalently. If it is the first interview in a case and it is substantive and an interview summary is being used to document it, then that automatic hour of non-production time will be granted. It is not the only interview that is allotted in a case, though. That is simply a time accounting detail. We are automating the first interview link to an interview summary. Interviews subsequent to that can also receive an hour, and they can also be granted. It's simply a time accounting feature here at the office.
Okay. Let's see. Practically speaking, if an interview request is denied, practitioners may be reluctant to quote unquote force an examiner to grant the interview. Can you speak to whether or not examiners are being encouraged to consider granting a second interview within one cycle?
Yes, I can speak to that. There does appear to have been some confusion about whether a second subsequent interview could be had in an application, and we have been busy clarifying that with our examiners and encouraging our examiners to grant interviews when they are appropriate. My advice is that if you've had an interview denied, make sure you understand why the interview was denied. And if it happens to be confusion over whether a second interview can be had in the case, revisit that or talk to the supervisor to revisit that.
Okay, thank you for that. Let's see. Is an application considered a new application for which the examiner will automatically receive time if an interview has not been conducted but a final rejection has been mailed?
So the round of prosecution and the automatic grant is not necessarily tied to whether or not an interview has previously been held. So every time that either a new case is filed or an RCE is filed, the system is going to reset to then key in automatically at the when the system identifies an interview summary form to grant that examiner 1 hour of time. And then again, if there's a second interview summary form, then in one round of prosecution, that time is not granted automatically.
Yeah, I got a little lost in that question, but I think it also included if there hadn't been any interview until after final, would the hour be granted? And it would at that point. That would be the first interview in that case.
Okay. Let's see. Can you clarify the difference between the PTO SB 439 form and the option that allows examiners to communicate via email in the AIR form? My understanding is that the 439 form allows any subject matter to be communicated via email versus the opt-in AIR form, which seems to only allow scheduling communications via email.
I think that's correct. I'd have to look into that, but I think that's correct. I think the option in the AIR form is simply logistical and not regarding communicating on the merits, and that if you're going to include communications on the merits, you need the authorization form.
Are examiners required to confirm receipt of an agenda?
I'm not sure if it's a requirement, but it's definitely a best practice and highly encouraged. But I have to go back to validate whether or not that is an actual requirement. I don't know, Bonnie, if you know if it's a requirement off the top of your head.
I don't think it is. I'd have to go back and check on that.
Okay. It was recommended to limit one-time interview for about 30 minutes. I'm assuming they mean to limit the time for the one interview granted to 30 minutes. If a first interview was limited to 30 minutes, can an applicant request another interview for 30 minutes, for example, even after the final office action? And I assume this is getting at the hour of time, and if it is only taking up a portion of that hour, can they then have a subsequent interview to make up the difference?
Sure. So I'll use this as an opportunity to kind of reiterate that the grant of an interview is not contingent on whether or not the 1 hour is allocated to the examiner. The 1 hour, the thought behind it is to give an examiner a half hour for preparation and then a half hour for conversation or during the interview, with the goal again to ideally have interviews be 30 minutes or less. That being said, if there are instances in which further conversation is needed, it is absolutely within the purview of the applicant to reach out to the examiner to request establishing additional interviews in order to further the conversations, and it would be up to the examiner to grant the interview request or not, depending on whether or not they believe prosecution would be moving forward. In addition, if one interview has already happened and they received an hour for that, the examiner could also then discuss with their SPE, if the interview is granted, getting additional time where warranted in order to have those conversations.
Okay. Moving prosecution forward is broad and may be interpreted differently. What type of amendments would be considered moving prosecution forward, and who decides whether the proposed amendments are substantive and/or move prosecution forward?
So I'll start and then see if Bonnie has anything to chime in on. So ultimately, it is up to the examiner's discretion on whether or not to grant an interview, especially based off of a conversation with their SPE. I would say that the term moving prosecution forward is extremely broad. It's not even limited to amendments. If you're just discussing claim interpretation or particular aspects of references that may need clarification, to me, that would also be moving prosecution forward. But it really is up to the examiner to weigh kind of where the case is at, the conversations that have already happened, both through interviews and on the record, in order to determine whether or not the requested interview would actually move prosecution forward.
Yeah, the only thing I would add is to remember the reason we de-automated the automatic grant of time to happen with every interview summary that gets entered. And that's because there were unintended consequences. Our examiners are very devoted to making sure that they're documenting everything that needs to be documented in a case. And so every phone call they would make, every interaction with an attorney, with applicant, would be recorded in an interview summary. And it was resulting in an hour being granted. So an examiner who is simply trying to document every move they make, like they made a phone call and got permission to correct a typo. If they enter that interview summary to document the conversation, it would automatically grant an hour. And that was an unintended consequence of that automation. So we undid the automation to be able to control for that unintended association of an hour with activities that an examiner ordinarily wouldn't ask for time for.
With so many software systems available for video and teleconferencing, i.e. Teams, Zoom, etc., does the USPTO only use one system, or is this open to use any number of available systems? And I assume, can you use any system to conduct an interview is the crux of the question.
Sure, so I'll take that one. So current USPTO policy is examiners can only use USPTO systems in order to conduct collaborative interviews via systems such as Teams. Currently, we only have Teams available to us as examiners, and so that is the system that we will use. That being said, the office has used other systems in the past, such as WebEx. It really just depends on where we are at the stage, given our IT. But it will be done through whatever collaboration tools are available to the examiner at that time.
Okay. If two examiners sit in on the interview, the junior examiner who did the search and a primary examiner, how important are each examiner's relative positions in the interview? And I'm going to rephrase the question. If there is a junior examiner that does not have signatory authority, and a more senior examiner, a primary supervisor who does have signatory authority, can you speak to the positions of those and the dynamics of that in the interview?
Yeah, sure. So I'll start there, and Bonnie, you can chime in if I miss anything. If you're in a situation where you have a junior and a primary sitting in the interview with you, the thing to understand is that it is the junior who is actively working the case and will have the best in-depth knowledge about particulars of the case. However, it will be the person with signatory authority who is likely going to be signing the office action and will be reviewing the work of that junior in order to make sure it's legally sufficient before it is mailed. So I would say that be cognizant that it's going to be the junior examiner who's really going to understand the nuances of the technology, the ins and outs of the claims, the particulars of the prosecution history that is being done. However, it's going to be up to the primary examiner to make the final calls on things such as allowability, whether or not the action should be final in consultation with the junior examiner. So there's a slight difference of their roles and responsibilities when you're in an interview.
I would only add one other comment to that, and that is often the role of the primary or the role of the SPE in the interview is to be training the junior examiner. They're helping the junior examiner to learn how to conduct an interview and how to move that interview forward and make it productive. So the interaction will often be with the junior examiner with that primary or SPE, just coaching them on how to move the interview forward.
Okay, thank you both for that. This is probably our last question, as we're down to maybe our last 60 seconds or so here. If the office introduces new grounds with no RCE filed and prosecution is reopened with a second non-final entered, is an additional interview hour automatically granted? Is this situation handled in terms of the interview perspective the same as if an RCE were filed? So if an examiner determines that they would like to reopen prosecution or issue a second non-final to better clarify their position on the record, does that reset the ask for an additional hour?
So that would not reset it, right? So that would still be viewed as a single round of prosecution. That being said, that to me is an instance in which the SPE would be very likely to grant the additional hour of time, right? So while this is still the single round of prosecution, and so the time is not automatically granted, again, there's a lot of things that the SPE would be thinking about, including, what does the prosecution look like previously, whether or not this individual conversation would be moving the prosecution forward. And to me, that would be something that would be taken into consideration by the SPE in granting the additional hour.
Okay, thank you for that, Dan. I'm looking at the clock here. We are at time. So with that, I want to say a huge thank you again to both Dan and Bonnie for taking time out of their busy schedules to join us today. If you do have additional questions, you can feel free to send them to the box, USPTO Hour at uspto.gov. As a heads up, there is a post-event survey that will be sent to you at the email address that you used to register for today's program. We would very much appreciate it if you take the time to fill that out. Good, bad, or otherwise, we use your feedback and input to better serve you with these type of programs and others here at the agency. With that, I hope you all have a great rest of the day and week, and we'll see you somewhere soon. Thanks.